what I want to do is take a slight step back and ensure that everybody understands how seriously the FTC takes not only safe harbor enforcement, but privacy enforcement in general, because safe harbor enforcement is a big part of our overall enforcement program. I mentioned yesterday during my speech that we have brought 40-plus privacy cases, 60-plus data security cases. That does not include our sector-specific cases. It does not include our Children's Online Privacy Protection Act, 21 actions brought there, our FCRA cases, 100 cases with more than $30 million in fines for entities that were violating the Fair Credit Reporting Act. Do not call, another area that's starting to become active here in Europe. We have taken exceedingly serious. We've brought 103 cases for $130 million in fines and $1 billion in disgorgement. Safe harbor is a very important part of our enforcement program, but we needed to have complaints. And between the year 2000 and my staff tells me 2010, despite the fact that Galexia's first report was in 2008, until 2010, we did not receive any complaints with respect to safe harbor. We still have not received any complaints from DPAs here in Europe. We would, as we've told our DPAs, both in private meetings as well as publicly, we welcome complaints. And I'm very happy that there is someone like Chris. I do not agree with his assessment in all regards. I don't think he has adequately described the FTC's enforcement program or consent decrees, and hopefully we can get into that. But I do appreciate the work that he does, and the reason he's able to do his work is because the Safe Harbor program is transparent. He is able to go online and see who claims to be a member. He's able to compare that by doing some quick searches with those who claim in their privacy policies to be members of Safe Harbor. He's able to do a lot of analysis because of the transparency of the program, which is, in my view, one of its big benefits. But back to enforcement. I'm trying to remember Chris's timeline vis-a-vis our and my timeline. I'm not sure they precisely line up, but we have now brought 26 cases involving safe harbor violations. And those 26 cases began when 4 key people came to the commission, that is the Federal Trade Commission. John Leibowitz, our chair that was appointed by President Obama, myself, Edith Ramirez, and David Vladeck, who became the Consumer Protection Bureau chief. I believe, and there were a lot of other people involved with this, Hugh Stevenson, who's the head of our International Consumer Protection Bureau, and many others. So I don't want to just mention those, but I think that if you were to overlay onto the timelines that you've seen some of the changes in personnel at the FTC from the very, very top on down, you would see that there's been a sea change there too. And that is part of the reason, if not a very large reason, why we have started to enforce safe harbor aggressively and swiftly as compared to many cases that we bring. So I'm sorry, I want to mention that of the 26 cases that we've brought, they've involved claims, false claims of registration, false claims of safe harbor compliance, and probably from my perspective, the 2 more critical areas are substantive violations of safe harbor, which involve some very large companies, Google, Facebook, and MySpace, as well as a very key action involving one of the certifying entities with respect to safe harbor, and that is trustee. The orders that we enter into with these companies should not be taken lightly, and this is where, for those of you who were in the last session, I do not agree with Chris in terms of his way of describing what FTC enforcement is about. These orders last, typically speaking, 20 years. On occasion, they're 10 years, but the vast majority of them are 20 years. They do require that the companies comply with safe harbor. But this is no different than any other enforcement action that we bring under Section 5 or under many of the other sector-specific laws that we enforce. That is, what we do is we bring the company into compliance by requiring them to comply with the specific provisions of the law. But we do much more than that. They're required to file biannual assessments with us, which means for 20 years, they have to file every couple of years a deep assessment with us to show that they are in compliance. They also have to send the information about the order throughout their company so that everybody understands, everybody in a position of responsibility understands that they need to comply. And then, of course, there's the public aspect of these orders. That the phrase has been naming and shaming. I like to call it reputational risk and reputational harm, but I think we're talking about the same thing, and I think that it's an incredibly important issue. So the other thing that I have heard quite often from companies is that entering into these orders, while very painful for them, also can lead to a complete rethinking and a complete reassessment of how they are doing privacy controls, what kind of protections they have, how data is flowing, whether they are truly minimizing data, basically a kind of top to bottom analysis of what they're doing. So while the process is painful, they often realize that it actually is a very good thing at the end, and it's very, very good not only in terms of their compliance with us, but very good for their consumers.